Thank you, Professor Alexei, and thank you for this opportunity to be in my very first time here in Astana, in Nazarbayev University, and my congratulations for this very interesting international conference about constitutional courts. I'm from Lisbon, Portugal. Nova School of Law, that is a public new university in Lisbon, and I'm a full professor of constitutional law and public international law. And it's a great pleasure for me to share with you this day, 1st of April, with a lot of information about our constitutional systems. So it's very good for me, this opportunity, and it's a very important moment in my academic life. My presentation will talk about general issues and some future challenges we'll have in order to have a better constitutional courts in the environment of rule of law. I think this is our aim, our collective aim, and I would have my opinion, and I would give you my reflection about some important issues. Here we have my email address. If you want to contact me later, I'll be available, obviously. And this is my website, where you can see some other information about my academic publications. Let us start. So in this field, let me see if I can, yes, I can change, yes. This is the summary of my presentation. First, an overview about the rule of law as a constitutional principle in our constitutional states. Just to remember, after that, some main features of constitutional states, and then focusing specifically in the position of the constitutional courts, advantages, disadvantages, and perhaps 4 challenges I have chosen to discuss about in the future of having a more perfect constitutional jurisdiction. That is the reflection I would propose to you. First of all, as we know, we live in our states in the rule of law principle. We can also give some different names, like état de droit, rechtsstaat, but is a common model to our states, and that means that we have a written constitution, we have a recognition of fundamental rights, and also a division of powers between the legislative, executive, and judicial powers. So this is the model we have in our countries. I think now is the best model, and is spread all over the world. Nowadays, I think we have few countries that do not follow this good model of organize our state and our democracy. Then, just to remind those features, written and rigid constitutions, that is the importance of having the fundamental rights and the competence of different organs well organized and written in a legal text that is the most important legal text in terms of hierarchy of legal order, and the recognition, a textual recognition of fundamental rights, not only in the text of the Constitution, but also through the recognition of international treaties. And the most important document, obviously, is the Declaration of Human Rights, the Universal Declaration of Human Rights, and democracy, political representation by elections, and the division or separation of powers between the 3 powers we have in the state. Now, specifically, the theme of protection of the Constitution. The starting point is that the Constitution is the lex fundamentalis, that is the highest law we have in our legal order. Why the Constitution is so important? Because of the contents, because there we have the identity of our society and our state, legal, fundamental rights, the competence, the rights from the society, the economy, the functioning of the economy, and important also because of the hierarchy, because it's the most high localized law we have in legal order. But the problem is that we must have attention in order to be attentive and to have good remedies to protect the Constitution. Because of its importance, highest importance and the so substantial contents, we must be very aware the danger we have not protecting correctly the Constitution. We have many mechanisms to protect the Constitution. We have political mechanisms, but I think the most important mechanisms or remedies are the judicial mechanisms or instruments to protect the Constitution. In that field, we have the judicial review. That is a judicial mechanism just to see if the ordinary laws or international treaties are or not according or consistent with the Constitution. As the colleagues before me said, we have in the world different models of having a judicial review about the constitutionality of laws. The first one was American model with not specialized courts, although the Supreme Court of the United States is indeed a specialized court about the judicial review. And we have an European model that was created by an important author and professor, that was Hans Kelsen, an Austrian professor. And the first constitutional court we had was the Austrian Constitutional Court. We also have, we also talk about a third model, that is a French model, but indeed the French model is not a judicial model of judicial review, because the French model, the Constitutional Council of France, created by the Fifth Republic, is not really, formally at least, recognized as a court, but as a council that is not the same in terms of having a full independent statute. But obviously nowadays we can include the French model inside an European model or inside an Austrian model, naming those institutions as constitutional courts. I remember my studies about the dialogue. We could, everybody read the dialogue between Carl Schmitt, a German professor, and Hans Kelsen, an Austrian professor, about who is the guardian of the Constitution. If it is a political model by the president, that was the proposal of Carl Schmitt, or if it is better to have a constitutional court, judicial organ, independent, that was the proposal of Hans Kelsen. And now we can see that Hans Kelsen was right about the better organ to protect the Constitution. That is, giving that power to the judicial, not to a political organism. But if I'm referring these two different models, or three different models, perhaps nowadays we have a main conclusion that those models are not so separate as before, because we are seeing the converging of these two models, because they have many similarities and few differences. So I think we are all together strengthening a model of judicial review by a constitutional court. So in the with that conclusion, we must, in spite of that, consider the advantages and disadvantages of having constitutional courts, just to be aware of the danger, and we must seek the new ways to avoid and to prevent those dangers. Obviously, there are many advantages of having constitutional courts, because the constitutional court has the highest position in the judicial hierarchy, similar to the highest position we can see in the constitutional law, the Constitution. Second advantage is having a specialized judges, only working with these constitutional issues, and as you know, those issues are not easy to work about, with a lot of political problems and moral problems, like abortion, euthanasia, and so on. I remember the most important last decision of the Supreme Court of the United States about the revocation of Roe versus Wade decision that was taken in this 1973 or two, I suppose. That was a big scandal in the United States around that new decision that put down the previous decision of Roe versus Wade. It's better to have specialized judges dealing with the constitutional matters. And perhaps a third advantage is having faster and well done decisions. Because of that, because the judges only do that kind of work, so they can work faster and better. But we also can see disadvantages of having constitutional courts. The conclusion is not a bad choice to have constitutional courts, but these advantages must have the function to sign the danger in the future we must prevent. What are the main disadvantages of constitutional courts? Political proximity to the political organs, a political designation, with judges that are not judged during all life, but only for a mandate, 6 years, 7 years in Portugal, 9 years mandate, and a political choice that is not mainly made by a merit, by the curriculum, merit and a good curriculum, but only because of political options from the different parties in the parliament, or from the political choice made by the president. The other problem, disadvantage, is the temporary functions. If you have a judge that is only a judge for 7 years or 5 years, is rather difficult to create a long jurisprudence doctrine to the future and to stabilize the decisions. Obviously, in that situation, sometimes the constitutional courts are considered as a negative legislator, or negative legislative function. Now, I would like to underscore some perhaps four challenges in the future regarding the situation we have in our countries. The first challenge is the relationship between the Constitution and the international law. I read the Constitution of Kazakhstan in this field, and we have the same problem in Portugal and perhaps in all our countries. What is the problem? The problem is that our constitutions consider themselves, obviously, as the highest level in legal order. But the fact is that if you look outside the public international law, public international law says the same thing about public international law. That is, public international law is considered the highest level in the world, even when you put the treaties inside the legal order. So the problem is that how can you compatibilize these different perspectives from the legal domestic law and from the public international law? Obviously, I think it is very important in this field to have a preliminary judicial review that is exempted the fact of the ratification of the international treaties. You may say no to sign and to be vinculated to consent the international treaties to put inside of legal order, if that treaty is considered unconstitutional. But the problem is this one. Imagine that the international treaty was already ratified and signed and is already inside the legal order in each state. Ex post facto, if the Constitutional Court considers that that some treaty is not according to the Constitution, what will happen? Normally, if you have an unconstitutional treaty, that treaty will be invalidated, will be declared without effect. But what about the liability of the state within the international community actors? Because outside the state, the state had assumed a compromise to be vinculated and to fulfill the aims of that treaty. And there is no way to, after the ratification, only by a unilateral decision, each state be free of putting in force and apply that international treaty. This is a problem, and in Europe we have this problem in a double, because we have European Union law that considers itself superior and supreme even over the national and over the constitutional level inside each state, and this is not an easy issue, and because of this we have indeed in the Portuguese constitution an interesting article, that is Article 8, number 4, that is an attempt to combine I think these opposite perspectives, that is the supremacy of international law and obviously European law, and the supremacy of constitutional law over the other branches of law, including the external law, that is international and European law. This is the first challenge I think we must face, and I don't know if is there any case in your countries relating with this issue. Second challenge is an obvious challenge, perhaps the main, most important problem we have, that is giving independence to constitutional judges. The problem is sometimes not having judges that are not designated by because of good reasons, but because of bad reasons. Someone that is appointed to the Constitutional Court just to have a favor or to have a gift by the politicians, just to have a status, not to work correctly defending the Constitution. What are the instruments or the arguments we can discuss about this? One way is to only give a judge a unique mandate, long but a unique mandate without any opportunity to be renewable. That's one way. The second way is the idea of having the diversification of the origin of the legitimacy of the constitutional judge. That is, not to have the same organ appointing all the members of the Constitutional Court, but spread all over the political system the choice of the judge from the three powers of the state, not only from the presidential power, not only from the parliament power, not only from the other judicial institutions. And another thing, because we have now a circumstantial problem in Portugal, because we have for the moment three judges that are still in function, but the mandate, those mandates had already ended, 9 years mandate, but the other judges could not reach an agreement till now to put an end to those mandates and to choose the three new judges. But it's not a very good situation we are facing now in Portugal. The third challenge. This is a more technical issue. But the problem is that you know the difference between the invalidation of law and the revocation of law, because when the Constitutional Court considers that a law is not according with the Constitution, that is an unconstitutional law, that law must not produce effect for the future, but even for the past. So all the effects, even the past effects, must be raised. So that law shall be considered as a no law from the beginning, from the very beginning of the existence of that law. That is, the decision of invalidate a law because of the law is unconstitutional is a retroactive decision. But what about the past situations? What can we save the past situation? Because people during 1 year, 2 years, 10 years consider that law a good law. Did not know that that law was unconstitutional, because the declaration of its unconstitutionality was only taken after, many times, many years after the beginning of that law. So what kind of effects we can save regarding the past of the force of that law? And is there any chance to reduce the effects only for the future, and save the effects that was produced in the past? And can, if the Constitutional Court decided to declare unconstitutional certain law, can the court can decide to have a provisional legislation until the Parliament made a new law, because the previous law was declared unconstitutional? That is a very interesting issue, but the problem is that if the Constitutional Court has the power to produce legislation, in spite of the fact that is a provisional legislation, that could be seen as a violation of the separation of power. But I admit, in some extreme situations, the power of the Constitutional Court to produce some provisional legislation. The fourth challenge I would like to draw your attention is about the programmatic norms and the social and economic rights. Because judicial review is easy if we are facing positive acts, that is, laws and treaties approved and put in force. But what about the situations when we don't have law? The problem is not so bad about treaties, but about the ordinary law, when we don't have laws, but our constitution has a mandate a duty for the parliament to produce the law in order to concretize and to put in reality the laws, the norms that are enshrined in the constitution. This is a problem about the social and economic rights, because social and economic rights are rights mostly for the future, and from those rights we can see some duties to the legislature, to the power, the parliament and the executive powers, in order to adopt the new laws and new regulations, administrative regulations, to change the social situation of the citizens, like the public health, or the public school, or the public culture, or the public security, social security. And we also can face a situation of unconstitutional law, not because of the law, but because of not having some law. But the problem is that is the same as we could see in the third challenge. The problem is that the constitutional law has no power to produce the need of that ordinary law. So in this situation, perhaps it will be a good idea to allow the constitutional court to produce a provisional regulation or legislation until the parliament has the opportunity to approve a definitive legislation about this lack of ordinary law. So this is a fourth challenge, not so easy. In Portugal, we have this mechanism that is the unconstitutional, an omissive unconstitutional, and in constitutionality, because we don't have the law we need to have, and we should have, but the parliament doesn't want to do the law, to make the law, and this is a problem, obviously, with some political and economic interferences, and sometimes the social and economic rights. Those rights depend about the economic and social circumstances, and I think that we cannot see the same binding force in liberties and freedoms as well we see in social and economic rights. So this is my contribution. If you want to know something else about the constitutional law in Portugal, you can see my book that is in English, published recently, the 4th edition, published by Wolters Kluwer. Thank you for your attention.